Yes.
All right. But did they show you still shots from that video and ask you if you recognize certain people?
They never showed me no video. I'm sorry, they never showed me no video of nobody getting shot. They
Right.
showed me a video of some people inside of a store.
At the gas station?
Yes, they never showed me when nobody got shot.
Of the Citgo, is that
They
right?
never even told me that nobody got shot right there.
Okay. Did you point out Nard and say that you knew it was Nard with 100% certainty because you've known him since you were 12?
If I said that, I lied because I don't know no Nard.
Did you sign your name to that?
I don't remember.
Were you shown a picture by Detective Thorpe or Gaither or Dennis in that interview of Duop?
I don't remember.
Did you identify Duop by his photograph?
I don't remember.
Did you tell detectives Gaither, Thorpe, and Dennis that you didn't really know Duop because he was Yak's partner?
I don't even know if Yak know him. I just telling you, I just making stuff up. But
Go ahead.
I think if I did tell them that, I told you I was just lying.
And did you tell, or were you shown a picture of Diamante Kendrick or Yak in that interview after you had talked to detectives Gaither and Thorpe? Gaither and Dennis.
I don't remember.
Did you identify a person as Yak during your conversation with Detective Thorpe?
I don't remember.
Were you shown a picture of Shannon during that interview with Detective Thorpe after Gaither and Dennis on August 5th, 2015?
I can answer and explain, right?
Absolutely.
I don't remember, but Thorpe know he was dead wrong talking to me, knowing how my mind was. Y'all put an autistic junkie in the interrogation room and expecting him to be honest.
Okay. Now, did
No, and I don't have a problem if it was for.
But I don't have it. Mr. Impeachment?
Was it admitted?
Yes.
Not
That's
in a-
totally finished, but I can't find it yet. So it's Mr. Sledge, Mrs. Zach.
With, yeah.
Plead guilty. I believe that I introduced a prior conviction of Mr. Sledge during cross,
Okay.
but I can't find it yet, so that's what Mr.
The prior conviction is one thing, the indictment alone is the other.
And I agree with that, but I'm not, and I'm not trying to impeach him with a prior conviction. That's something completely different. I'm impeaching him with bias and motive of what the police charge him with something, and then the DA's charge him with something under an indictment. And I'm just trying to make it clear that to the jury what the indictment that he was under when he went in and gave those statements.
Okay, so you could ask him that question. You can even read from it if you want to. But I don't think we need all of the language of the indictment nor the indictment itself. Just ask him, were you charged with, indicted for, and then whatever.
Okay, I understand.
And Your
That's
Honor,
fine.
and Your Honor, I'd ask that, as it's a document that won't be tendered or admitted, that Mr. Sharp not be allowed to sort of waive it in front of the jury. I know he didn't do it intentionally.
I was just
before.
trying
It
to
was
read off.
I'm not going to direct y'all about what you can hold in your hands.
I'm not-
Right, I was
that
just
wasn't
trying to
my
read
point.
last time, and I'll do my best to keep it on the lectern.
Mr. Steele.
Your Honor, I think it does come in, the indictment without the attached conviction, if we don't have the attached conviction,
Well,
because,
Mr. Sharp's fine with just asking questions about it.
well, if he's
so.
fine, then that's okay. But my belief is, at the time of the proffer, it would go to Mrs. Zachary. If he recognized the document, yes, that was my incentive. So it would be a relevant document.
I'm not saying it's not a relevant topic for examination.
Right. Yes.
We ready for the jury? Yes, okay.
What's up, peeps? Welcome to the channel. It's Tuesday. I think it's like day 36, 37 of the YSL trial. Defense is starting to do cross examination. Yes, technically, Love had 2 days. If you want to say half the day and half the day, and then a whole day. 2 days of direct. Yesterday she asked a lot but didn't get very far. Friday, however, she did some sneakiness and didn't want to clarify. And there's actually a clip when the judge asked her to clarify who she was talking about when she was talking about April 28th. Love is like standing directly in the camera, and the judge says, "Don't you want to clarify?" Something along these lines. Don't quote me exactly, but the judge says, "Well, tells her to clarify." And she asks her if she'll clarify. And she's like, you see her earrings going back and forth like she's shaking her head, no. But then she ends up doing it, and she, calls out Shannon's name. And then they end up going, and the judge calls a break. They go on a break. and and they kind of get into a little tiff back and forth. Yesterday, you can kind of tell Zachary was not feeling it. Now, over the weekend, there was a lot of back and forth because he fired his attorney. There's a lot of speculation as to why he fired his attorney. Some are saying like, oh, he wants to try to keep the money. Others are saying the attorney is like, I need a down payment, and they raised the money on GoFundMe or something like that. And so, you have to wait a certain amount of time before you can actually get the funds out. And the attorney was kind of like wanting something down, like for the work that he's doing, and not just doing this off of word of mouth, I guess, so to speak. And then the family didn't have the funds. It's something else that's been talked about. A lot of people were ticked off that he fired his attorney, and like, why would you do that? And honestly, I think this boy is listening to his daddy, and his daddy like, nah, you don't need no attorney. But either way, I don't think that was a smart idea, just because having an attorney there will kind of let you know questions that you can answer, questions that you can't, questions that may particularly be not in your best interest. And not only that, but your attorney is the one that you can consult with to make sure, like, hey, I don't want to answer this. It may implicate me. Is that all right? And, as you can see, the GA is less likely to mess with, hardcore with people when they have attorneys there. They're a lot more likely to just throw you to the wolves. But whatever. Neither here nor there. Now, today, there was some back and forth. And it's something very real particular that Love objected to. It was a line of questioning that Max Sharp did, and it was kind of like right before the end of the day. And Max asked him something about, like, did his attorney ever come let him know that, he is on probation? And Love was like, oh, that's a misrepresentation of what I said. Well, I found the clip, and I'm going to clip it in here. Now, I'm not going to lie to you. I'm not sitting in the courtroom, so I didn't hear exactly everything that was said. And I'm sure that they have better ears than me because they're right there versus me. I'm listening through what's being broadcasted. And there were several times that Love and Shibe were kind of back and forth on camera, but off the mic. So you really couldn't, me, a layperson, I couldn't understand everything that they were saying. However, there is a part where she mumbles under her breath, well, let him know he's on probation. And what else she says, I don't know. But basically, you put it out there. That's what I don't understand. You put it out there. Again, the state wants to say, oh, well, all the attorneys only want to talk to the defense. None of them want to talk to us. None of them want to deal with us. And then with the same breath, you turn around and like, well, yep, we threatening y'all clients and we threatening them with their probation and we might revoke it and da-da-da-da-da. It just kind of goes to advocate the point that, you guys are kind of doing maybe not so honest means of doing stuff, or maybe not so forthcoming or forthright or appreciated ways of doing stuff, kind of like some backhanded ways of doing things. And just like putting it out there, if your client don't testify the way I want them to testify, then just so you know, there's opportunity they may go back to jail, which is why they gave them 10 and 20-year probation sentences. Like, legitimately, Quindarius Zachary basically sat in jail for 2 years, waiting to go to trial, go to court, get a plea deal, anything, on charges for a gun that had matching shell cases to other crime scenes. And so they knew this gun was tied to him because he got caught with it. And they knew this gun was tied to other cases because of the shell cases. Basically, anytime something like this, anytime you get caught with a firearm, even if they don't arrest you on the spot or they arrest you and they let you go, what they do is they submit that firearm to either an in-state agency, usually in-state agency, where they then test that firearm. They basically shoot rounds through that firearm, match ballistics to see if these casings match any other casings for any other crime that has been logged into an internal in-state, meaning in-state, or a database, as in FBI type of thing. If those shell casings come back to any other crime scene, not potential, any other crime scene, if there's a match, if there's a hit, then what they do is they come find you, because now they have a crime, they have a weapon, they have a person of interest, because this weapon has been found with this person. Now, if you have, I guess, a decent alibi that, you know, you're all caught on camera at Walmart at 2:22 in the afternoon on the day this said crime was committed, then now they know you're not the person that did it, but they're thinking you may know who did it because you now have a weapon that has been at this scene. Kind of like what Zachary got picked up on. And so he goes into these meetings, interrogations, whatever you want to call them, and he talks about different stuff. Now, whether or not the stuff that he was telling was the truth in the moment, or if he was pulling a Woody, to be determined. But clearly now he's saying some of what I said was true, some of what I said was lies. You know, I just kind of mixed it up. I didn't keep up with it. It was what it was. But essentially, for him having that weapon, initially they were charging him with all of the aggravated assaults, aggravated batteries that was connected to that firearm that he got caught with, which he was then facing 189 years. By the time all of that was said and done, that's just that one case, not all the other cases he had pending or currently has pending, but just that one case. They let him basically serve the full 3 years on that. So he said he had 6 more months to do it, and I think that was on another case. But time served, let him out on that, and then they go give him, 20 years probation on it. All his other cases is all his other cases. That has nothing to do with that one. But the one they were initially trying to convict him of, which is the one that's now listed in the indictment for YSL, that he was a party to, that now they're trying to convict 28 other people for, it was initially on him. So basically, and this is where I get super confused, they charge other people with stuff. They list those other people in the they charge other people with stuff. Some of those people are listed in the indictment. Some of those people are not listed in the indictment. But then the ones that they don't list in the indictment, they charge all the other people that they've listed in the indictment for. Even though the person that pled to it and did it, they're not putting in the indictment. But just the initial crime itself is now everybody else's fault. I can't rationalize that in my head. You know what I'm saying? I can't. Like, that I don't know about it. I'm not a party to it. But she did it. And because me and her sometime had an association, you're going to put a RICO on me. And she's an indicted co-conspirator because we once knew one another. But her crime that she pled to, that she did time on, and she's still serving time on now, is somehow my fault. And I've never been convicted of it, never been questioned about it, never admitted guilt to it. But that's our law. It is what it is. Outside of that, I mean, Yak Gotti's lawyer went up Weinstein. He had probably a total of 10 questions. It was what it was. His cross, he predicted 20 minutes. It was more like 10. But Brian Steele, I think, is up next. I think Brian Steele is going to question Zachary. He's up tomorrow. We'll see how it goes. And, you know, it is what it is. Guys, we got 92 subscribers. I ain't gonna lie, I never knew I would have one. So I'm excited that I have 92 of you that listen to my rants and me talk crazy and on camera with my head not combed and ranting so hard that I make mistakes and get stuff wrong, but you call me out and you let me know, girl, you're messing up, get it right. So I appreciate all of you. I appreciate all of you for communicating with me. I thank you so much for tuning in and staying tuned in. I've been out sick. I'm still not feeling well, so I apologize. You know, it is what it is, but yeah, I'm trying to include at least a few clips so you know what I'm ranting about in my rant. So thank you guys so much for working with me, tuning in to me, and you know, like, share, subscribe. Thank you so much again, and you know, until next time, peace out.
Ms. Love, I appreciate the case law. And you are right that I'm not excluding, you know, evidence in its entirety. What I am trying to accomplish is for you to ask the questions about the things that are material, not every line or every other line, and I'm exaggerating a little bit, but not all of the minutia of what is in this statement, like how far away they parked when whomever did the shooting. I mean, does that really matter?
There's a reason that I asked that question. When there's a witness who talked about them parking at the stop sign. He may not have seen the other car, but this witness has testified that it was only him and one person who followed a car and shot at people. Yep. So the fact that there's a witness who testifies that there was a car that stopped up the street at the stop sign, and we have this witness telling police in August 2015 that they stopped kind of far back, and that the other car stopped in front of the house and shot. We believe that those details matter, and they provide what the court called, I think, evidentiary depth, and that the jury can look at what other witnesses unconnected with this witness say and decide which version of the statements that this witness has given is true and why.
So then you can just say, did you park really far away? And then he can say no. And then you can impeach with the statement. It's all that needs to happen.
Judge, I understand, but respectfully, we can't tell the defense how to ask questions, Your Honor, and I appreciate the court's suggestions regarding how more succinctly to ask the questions. But I don't ask the questions that I ask for no reason. I certainly don't ask them for the purposes of delay.
I know it's not for the purpose of delay. I think it must be because you think every tiny little detail is crucial to your case, and that's why you're asking every tiny little detail?
I don't think every tiny little detail for sure, but I do think that details matter. And
I know that you think that details matter.
And
all right, well, it's been 20 minutes that we've been on this one topic. Maybe we'll just cut our lunches down to 35 minutes from now on, since we have to hold the jury so far past when we're supposed to be picking back up. So please take it into consideration, but I mean, I don't know if you're going to do that or not. I don't know if I'm like even getting the concept through to you.
Your Honor, of course.
Okay, good. Let's get the witness back in and then the jury back in.
Regarding the last line of questioning by Mr. Shart, when the state objected based on the beginning of his question, and Mr. Shart asked the question that he did, are you aware that the district attorney told your attorney that you face 20 years of probation? This is not the first such kind of question regarding something that is improper that has come up. And I would ask court to remind counsel that that's not an appropriate line of questioning. It's not a relevant line of questioning. And it's just an attempt to essentially cast aspersions on opposing counsel. And I don't think that that is proper, at least not the question that he asked.
Your Honor, I wasn't casting aspersions on opposing counsel. I was casting aspersions on what opposing counsel did. I couldn't
Same
believe
thing, Your Honor.
Can I finish? I couldn't believe it when I was in court the other day and a DA is sitting there talking to, in open court, to the attorney of a witness and is openly saying, I just want to remind him he's on probation for 20 years. I mean it. And my thing is, she knows why she said it.
Your Honor.
That message was to be relayed to to Quindarius Zachary. That's the only reason it would be said in open court. And I assume that Mr. Scheib, in his short tenure as attorney for Mr. Zachary, conveyed that message because that message was made loud and clear in open court. And Mr. Scheib was not the one that needs to testify, according to the state. Mr. Scheib's not the one on probation. Mr. Zachary is. So yes, when the state says to about a state's witness to their attorney in open court, I just want to remind him he's on probation for 20 years, and I'll charge him with perjury and will revoke his probation. Whatever was said, I would rely on the transcript. Yeah, I assume that message has been relayed to the witness, and I do believe it was intimidation. I'm not going to sit here and say it's witness intimidation and all that. I'm not saying that, Judge. What I'm saying is intimidation in the colloquial layman's term sense. It was a message that was sent, and I wanted to see if he received the message because that is relevant to his bias and motive in testifying.
Your Honor, Mr. Sharp knows that, number one, all of the things that he's representing as being said weren't said, and he still knows that that was an improper question to place before this witness. And to the extent that any attorney is asked something outside the presence of the witness, to ask the witness, was he aware of something that was said outside of his presence? Mr. Sharp has no good faith basis for asking the witness a question. It is not relevant whether or not the witness's attorney, some other person, was told that his client should not commit perjury. And I don't think all of what Mr. Sharp said was even what was actually said. But the question that he asked the witness was not a proper question. It was just an attempt to paint a lie to the jury that someone is trying to intimidate this witness, when frankly, the only person that the witness has been friendly to is all of his friend Shannon's lawyers. And Mr. Shive is talking to Mr. Stillwell's lawyer, and Mr. Shive is representing Mr. Zachary. So the idea that somehow the state is trying to intimidate a witness is ludicrous, when and that the lie that he's putting before the jury that is what is happening is improper, and he knows it's improper. And I would ask that the court keep him from making those types of false assertions, false representations, misleading representations before the jury under 403.
Note, Your Honor, that not one time when Mr. Zachary was on the stand did I claim that Miss Love intimidated him. I never used the word intimidate in front of the jury. I'm talking about. What I said was, are you aware that Miss Love talked about your, I can't quote directly, but talked about you're still on 20 years probation, which was said. I don't even independently know how many years probation is. The only reason I know is because Miss Love said it in open court. So everything was factual. And, I think it's relevant when a DA is saying, and I'm not trying to pick a fight with Miss Love. If people are difficult witnesses, we all deal with difficult witnesses in different ways. So I'm not even trying to judge what she said or how she said it. All I'm saying is it was said. And I wanted to know if he got that message, because that message was clearly intended for him. It wasn't intended for Dennis Shive.
Well, I'm not sure that's true because at the time, I don't think they had yet negotiated the terms of the immunity deal. But Ms. Love, your objection was sustained. So that's really all there is to it.
Your Honor, I think the main thing to it is that Mr. Sharp keep talking.
Ms. Love, I'm going to take a bathroom break, okay? I haven't had one for the last couple of times that everybody else has.
Until yesterday.
Excuse me, can y'all mic up? Can y'all use the microphone?
Yeah, just walk back to the podium. You'll only be 3 feet further away, and then they can hear.
I'm sorry.
It's okay.
I didn't know until yesterday he was part of this 10 years ago. I did not know. He did prison time, but I didn't know that he was part of this. And as far as immunity, he could be brought in. I mean, as far as conspiracy, and if he goes up and testifies and says, hey, I was involved in this and involved in that, they could prosecute him. I didn't know that until yesterday he was involved in this scenario.
Okay, I don't quite know what you mean by he was involved in this scenario, but
He did time for some of these acts involved in this.
well, he certainly can't be prosecuted for anything he's already done time for. I mean, that's double jeopardy.
Well,
And
I don't know if, as far as conspiracy to commit murder and everything, I don't know what he was prosecuted for entirely. I just found out, and the family has told me more today. I thought I was getting involved in, I'm fine on it, getting involved in a scenario where I was going to help him, give him information, whether testify or not testify.
Right.
But it turned out to be, and that's fine. I like this. It's a lot more to it. So I have to protect him.
I understand. So, I mean,
Judge, I don't have any problem doing that, but I just do want to make the record very clear for a couple of things. I don't believe that Mr. Shive has, and I don't think the court entertained it, so it may be worth nothing, but the competency, Mr. Shive doesn't have, I don't believe, maybe I'm wrong, standing to assert regarding a hearing regarding competency as far as this person as a witness. But second, given, I don't know what all Mr. Shive knew, but given given the communication between Mr. Zachary's father and our office,
right.
I don't know how, and given what I was told, not yesterday, but I think day before yesterday, regarding what Mr. Zachary would and would not do and why, I don't know that I don't know how that there was no knowledge of what his involvement in this was. There was specific commentary, and I'm not saying that.
I don't know either, but I mean, Mr. Shive's right. Based on the way this case has been indicted, even, I mean, the RICO count seems to be something that if the state wanted to, they could indict anybody on who had any involvement in any of the crimes, even if they've already been, I mean, I don't know that, at least be indicted. Whether it would hold up or not, I don't know. But
so, Your Honor, as in as much as there is a concern, I assume that there is a concern regarding Mr. Zachary, I don't know, implicating himself in something that he could get indicted for. We don't have any problem asking the court to compel his testimony pursuant to the same statute that we have had to compel others. we don't have any problem doing
All
that.
right, well, it sounds like y'all might need to get some sort of an agreement in place between
Right.
yourself and Mr. Scheib.
Definitely like something in writing.
I mean, that's basically what you're saying, Mr. Scheib, right? Is that he,
But
Part of the situation.
And also, I think I ought to make Mr. Scheib aware. I just want to make sure he's aware that part of the requirement for that statute is that he not commit perjury on the stand. And Mr. Zachary is currently on probation for a long period of time. And so I'm gonna put that out there. That's it.
all righty. Well, Mr. Scheib has been a defense attorney for more years than probably he can count anymore. And a good one, a highly experienced one. And so he'll be able to advise his client as to all of the, potential drawbacks and dangers and what have you of such an
It's not a
agreement.
easy, clear-cut scenario. We're going to wade through some things. Okay.
Okay. So we'll draft up that document.
Okay, but considering that it sounds like it may be as early as tomorrow morning that, I mean, I don't know.
We'll have that.
Doesn't sound like anybody knows yet. It's a developing kind of thing about when he might be released, but y'all need to get on that.
So we'll have that drafted this afternoon for
All
Mr. Scheib to review.
And
It's
Mr.
fair.
Scheib, if you want to communicate with my office about wherever we might need to be able to talk to other courts
Right.
about your presence here.
I have a simple way of doing it. If you issue an order me